Can a school district really walk away immune when its employee commits murder off campus? This comes from a recent case where a mother trusted her child with a Los Angeles Unified School District employee, and then the school employee beats her 6-year-old child to death. So the case goes to trial, and the jury delivers a $30 million verdict against the Los Angeles Unified School District, but on appeal, everything changes. I'm Eric Ganci, and this is Law on Edge, bringing you cutting-edge laws to keep you at your sharpest. Welcome to Law on Edge, a podcast presented by Antonio and Miranda and hosted by me, Eric Ganci. I'm a California trial lawyer, and each week I break down new case law and courtroom strategies that could impact your practice and your daily life. With that, let's dive into today's case. Today's law is California Education Code Section 44808, and it can be brutal in its simplicity, but so many times the law is not simple nor clear. So what happened in Taylor? We start with the school district, the Los Angeles Unified School District, which I'll call LAUSD, who hired employee Tyler Martin Brand as a part-time playground worker and supervisor for their Beyond the Bell after-school program to then later supervise an after-school program at the school. Plaintiff's then 6-year-old son attended that school, but not the after-school program. Then plaintiff asked Martin Brand to babysit her son. The next facts are important. Although plaintiff did not know where Martin Brand lived and knew little about his background, she obtained Martin Brand's telephone number and arranged for him to pick up her son and babysit him at Martin Brand's home. Taylor trusted Martin Brand because he worked for LAUSD. She did not tell anyone she was going to ask Martin Brand to babysit her son. One of Martin Brand's supervisors later learned he had been babysitting students, but the supervisor was unaware of that fact before Martin Brand babysat plaintiff's son here. The next point is also very important. LAUSD policy prohibited school employees from interacting with students off campus except during school-sponsored activities. Sadly, Martin Brand beat plaintiff's son to death while babysitting him. Plaintiff filed a lawsuit which alleged that LAUSD negligently hired, retained, and supervised Martin Brand, and that this negligence was a substantial factor in harming plaintiff's son, ultimately to his death. The case went to trial, and the jury returned a special verdict finding that the school was negligent in hiring and supervising Martin Brand, that plaintiff's mother was also negligent, and that both parties' negligence was a substantial factor in causing harm to plaintiff. The jury awarded plaintiff $30 million in non-economic damages. It attributed 90% of fault to the school and 10% of fault to the plaintiff, and actually 0% to Martin Brand, the murderer. The school then filed a motion for judgment notwithstanding the verdict, which is called the JNOV, and a motion for a new trial. Both motions asserted the school was immune from liability for the death pursuant to California Education Code Section 44808, which provides that no school district shall be responsible or in any way liable for the conduct or safety of any pupil of the public schools at any time when such pupil is not on school property, except when the district has specifically undertaken to assume responsibility for the pupil. After hearing argument, the trial court denied both motions and held in favor of plaintiff. The school appealed, and the Court of Appeals agreed with the school to overturn the trial court's ruling. So let's talk about the law here. First, a quick note on JNOV motions. The law is this. A motion for judgment notwithstanding the verdict may be granted only if it appears from the evidence, viewed in the light most favorable to the party securing the verdict, that there is no substantial evidence in support. So let's go back to this case. So next, the school argued California Education Code Section 44808, which I discussed earlier, which states, no school district shall be responsible or in any way liable for the conduct or safety of any pupil of the public school at any time for which the pupil is not on school property, except when the district has specifically undertaken to assume responsibility for the pupil. So the court here analyzed and agreed with this case, Mosley versus San Bernardino Unified School District, a 2005 case cited as 135 Cal App 4th 1260, where a high school student died after falling off a van driven by her basketball coach, who was a former school employee. The student's parents filed a wrongful death lawsuit against the school district under a negligent hiring and supervision theory. The trial court there concluded the district was immune under Section 44808 and sustained its demurrer, so holding in favor of the school district. In the end here, the court found that this school is statutorily immune from liability and reversed the order and judgment from the trial court. But let's talk about some what-if hypotheticals. So let's pause and just say, what if things had been different? What if the supervisors had known that Martin Brand was babysitting students? What if they had received complaints or rumors or even subtle hints and ignored them? That could have changed everything. Evidence of knowledge or even willful blindness might have pierced the shield of immunity. The court could have said, you assumed responsibility the moment that you tolerated this babysitting. And if so, then that $30 million verdict may have stood. Here's another what if. What if other parents had also used Martin Brand as a babysitter and the school quietly tolerated it? That could have turned isolated misconduct into a systematic failure. This case reminds us about something, that one piece of knowledge can swing the outcome of an entire lawsuit. And here's some strategy implications, meaning what can this mean in your practice? How do you use this information? Something to look into is just who is the employee and what is the school, like what do they know and what should they have known? Because in law that is so important. Did they know or should they have known? And if they knew or should have known that an employee was doing stuff after hours, and if they were approving of it, even approving by silence, that may be something to look into. So it just really depends. Like if we have a break in like the employee is like clocking out and leaving the school grounds, and then everything happens off school grounds, it needs to be evaluated to see if there is a connection either by action or inaction to see if the school is still a part of that employee's actions. For plaintiff lawyers, dig into memos, policies, staff emails, oh my God, the emails, all the emails, and acknowledgments from supervisors or other employees that they knew or should have known that this was happening, this babysitting or abuse was happening. Depose the staff. Ask if babysitting ever came up, because without that proof, Section 44808 may close the door on liability. For defense lawyers, this case may be a gift, and immunities are some of the strongest defenses. Section 44808 can be your shield. For parents and citizens, this case can be a brutal reality check. Just because someone works at a school does not automatically mean the school is on the hook for liability when or if that person is technically off duty and causes harm to somebody else. The law may not follow your trust, and that gap between instinct, trust, and statute can be where this heartbreak lives, as it did for this case. Here's the edge here. California courts can draw a bright red boundary at the edge of a school ground. Sympathy and devastating facts and injuries, even death like here, may not override statutes, and sometimes emotions may not trump immunity. For Taylor, that meant a $30 million verdict is now overturned. And for the rest of us, it's a sobering reminder in law, justice, and accountability may not always walk hand in hand. I'm Eric Ganci, and this is Law on Edge, the sharpest look at California's changing laws. Subscribe for more courtroom strategies, new cases, and insights that keep you on the cutting edge. And of course, if you ever need help with the case, reach out to us.